I think that I shall never see a webinar as bad as thee. At least another webinar would tell me something I could. Now, that made no sense, and it was unrehearsed, as will be the rest of this webinar. So, my advice to you is to watch another webinar, or maybe have 2 cups of coffee before you listen to this one. Turn the volume up or turn the volume down and enjoy this clown. Alan, that's the best I can do. Now you give them the best you can do, which is going to be disappointing. Okay, thank you. That was a rousing introduction. Very much appreciated. I just lost my video. I hope I can find me, but I'm here somewhere. This is Alan Gassman, and I am here today with you to talk about this topic, which is, let me get there, what to do with your installment notes and intentionally defective grantor trusts. Opportunities abound. We've got a nice crowd here, a lot of very smart people attending. I'm almost intimidated by the intelligence on this webinar. So please do send me questions, send me answers if you're going to send me questions. And good morning to you, sir, David. Thank you very much for that nice introduction. And we will be guaranteed to talk about guarantees. So a great many really good advisors and well-advised individuals have engaged in installment sales, and certainly more people will be engaging in installment sales, especially for federal estate tax planning this year, for reasons we'll talk about. What we're going to concentrate on, though, is what you do for individuals and families who have significant promissory notes, and what opportunities and what traps are out there for those notes. And we even have a March 5th tax court case that I'm very pleased to talk about. If you have a question, just ask the puppet. What you do is you click on the upside down pyramid and then type your question, preferably upside down, then we'll hold it in a mirror, and if we know the answer, we will answer it. In a few hours or a couple of days, depending on Brittany's schedule, we'll be posting this webinar to our YouTube channel. So you can go to Gassman YouTube, and you'll see all those fun people having a great time watching our YouTube videos, and you can be one of them. April 3rd, that's Thursday, I'll be on with Marty Schenkman and some other software companies talking about different opportunities for estate planners, and in particular estate planning lawyers, to use software. So this will profile Estate View, Decision Vault, Estatably, FP Alpha, and another one. So it's a nice program. And then on April 4th, we'll be talking about essential building blocks for estate planning, improving your intake, which can always be better. What's more important than first impressions? At 12:15 today, which is in 1.7 billable hours, I'm going to be on a second talk, and we're going to just do questions and answers on Estate View. I'm going to have a young lawyer, Peter Farrell, on, and he's going to show me how to use my computer for the first time. So that might be interesting. Anyway, let's go straight to the matter at hand. The materials you're about to see are primarily from a Weinberg talk that we gave December 22nd, 2021, back when Brandon Ketron was young. And he helped me with these slides, and he's smart enough not to work on Saturdays. So we'll see how we do. We first invented the Biden two-step with Jonathan Blottmacher and Marty Schenkman to talk about, and Jerry Hesch, to talk about the transfer of assets to a defective grantor trust in exchange for a promissory note. And why would you enter into that type of transaction? And by the way, I'll be glad to send you our article of August 10, 2020 on the Biden two-step, the installment sale to the Grantor Trust, which I did not invent, by the way. Jonathan Blottmacher did, apparently. Why would you do it? Well, besides the fact that it's very profitable for your lawyer, if you put $20 million worth of assets into an LLC and you had spouse one form a spousal limited access trust for the health, education, maintenance, and support of spouse two and put $700,000 into it as a gift, and then spouse two, who doesn't like spouse one, forms a trust for descendants only, puts $700,000 of assets into it, and then this $20 million LLC is divided into 1% voting that spouse one and spouse two initially retain, and 49.5% non-voting. They value the 49.95% non-voting at a 30% discount, which is a fairly low discount compared to what the bigger valuation firms advise. And all of a sudden, 20 million turns into two notes of $6,930,000, bearing interest at the long-term applicable federal rate if these were 20-year notes, which would be common. And back then, the applicable federal rate was only 1.35%. That's changed. The cost of money has changed. So now these people have done four wonderful things. The most wonderful thing is they've supported their lawyer, their accountant, and a valuation expert. It's been good for the economy. Thank you very much. Secondly, a $20 million net worth just went to become a $14 million net worth. You see a little bit of value there? Third, and most important perhaps, is instead of $20 million growing at 6, 7, 8%, maybe even more, they have 14 million growing at 1.35%. Fourth, which becomes the most important thing after 17 or 18 years when you run the numbers, spouse one and spouse two happily pay the income tax on this $20 million portfolio. The interest, the dividends, the capital gains, they pay the tax. That's not a gift. So 10 years later, 15 years later, the portfolio is worth 40 million. If they were to liquidate the LLC, each trust has 20 million minus 7 million, 26 million out of their estate based upon 1 million for in gifts. And that's, quite frankly, not a bad day, is it? So now, what if they come to me today and there are 17 or 18 years left on this note, and they say, Alan, we don't really like these notes anymore. We'd like to get some assets out of these trusts. It's been a lot of fun, but should we continue the arrangement? Or should we just get our $14 million back? Well, they can't get $14 million back. This is one of those good news, bad news things. And I've got a great good news, bad news story, but I won't go into it. So I went to ChatGPT this morning, my friend ChatGPT. He's right half of the time. He's wrong the other half of the time. And I asked, what would be the value of an 18-year promissory note if it had $1 million in principal and it was paying interest at 2% a year for 18 years, and the principal was due in year 18, and I'm going to use a 5% discount rate. Now, something quite beautiful about beautiful, I don't know what that means, but something quite beautiful about the estate tax law and the gift tax law is that when you give a note at the applicable federal rate, even though that's below the fair market value rate, it's not a gift under the gift tax law, under Internal Revenue Code section 7872, under the Frazee case, and this month under the Golly case. So on the other hand, when you go to value that note when you die or when you sell it, what is it worth? Well, according to ChatGPT 4.0 this morning, it is worth, well, 64.9% of the face value. And that does not take into account lack of marketability, lack of collectability, and all the things that a valuation firm may put into this. Now, the numbers may be wrong. One of you somebody watching this may want to be running this on a spreadsheet, but according to ChatGPT 4.0, a very uncredible source, a 35% discount. So after verifying this with a valuation expert, these clients, instead of having a $14 million in notes owed to them, Alexa, what's 65% of 14 million?
65% of 14 million is 9.1 million. By the way, you have a new notification.
Alexa off. I'm glad she didn't remind me to take my medications. So we have, what did she say, a $9 million value now? We've reduced their estate from 40 million to 9 or 10 million. If they want to take the note back. Now, what if one of them is in poor health, may die soon? What if there's a low asset, a low cost, high fair market value asset worth 9 million that they could take back, put in his or her name? Then that sad event of death happens. The happy event of a fair market value basis increase happens, and we're off to the races. Now, I do question, is it better to give them the 9 million back and then borrow it now again at 4.75%, the present applicable federal rate? That may be better. Or maybe they want to switch to a self-canceling installment note. But that's one of the opportunities that we have here. And I know you're breathless from watching that. Actually, it was the description. But now let's talk about golly gee, the Golly case. So I like to think of a name for every case or a story for every case. And this is golly gee. And then the IRS was sent home by Judge Holmes. Oliver Wendell? No, another Judge Holmes. Mark V. Holmes. And what happened on Golly is that Barbara Golly, being the wonderful mother that she was, made a loan to her son in the amount of $2.3 million in 2013, which was the midterm applicable federal rate, 1.01%. And she did not file a gift tax return because she felt it was a loan. The son signed a promissory note. There was no collateral. The decision does not say the son was not collectible. He must have been collectible at the time of the loan because he had the $2.3 million. He paid interest on the loan. She reported the interest on her income tax return, and the IRS took the position, apparently after she died and filed an estate tax return, that this was a $2.3 million gift. And what I'm missing here is why this went all the way to tax court. Why the government spent all the money to go to tax court, and the taxpayer had to spend all the money to go to tax court when you had all the evidence that this was treated as a promissory note. So to me, the judge didn't spend much time on this. It was page 1, page 2, page 3, and you're out. The judge did not award attorney's fees or costs against the IRS. That would be a high standard. But what this case shows is, of course, the IRS recognizes how potent the ability to loan money at the applicable federal rate is, and the IRS is fighting these. So when we make the loan, yes, sign a promissory note, give collateral for the loan if at all possible. When we structure our installment notes, there is always collateral for the loan, whether that's a pledge of the LLC interest that you're transferring, a UCC1, a mortgage. That would have put you one step ahead of the taxpayer in the Gali case. Make sure your borrower is collectible. That's what that 10% down payment that I showed you was, a $700,000 gift on a $7 million promissory note. And maybe more collateral would be good. As David points out, it's not a bad idea to have a guarantee. If her son had a negative net worth because she was bailing him out of a creditor problem, which of course never happens in wealthy families, right? Then maybe her spouse or her friend or somebody should have guaranteed that note. If they had collateralized the note, maybe they would not have had to go to tax court. Now, I have not read the briefs yet. I just found out about the case this morning when I read my Lineberg Saturday summary. If you don't subscribe to Lineberg Information Services, send me an email. I'll be glad to introduce you to them and get you a free trial. But unfortunately, the Gali family did not have a free trial. If you'd like to look at their briefs, and I mean not their underwear, but what the family submitted to the court and what the IRS submitted to the court, I'll be glad to send those to you. We're going to be writing an article on that. I hope to have it out on Monday. David, if you can give me a quote, I'll be glad to quote you in that case. Anyone else, if you can give me a quote, I might quote you in the case. All right. So there's a lot. And by the way, Lineberg has this, I think, on their website, the 2021 Biden two-step, and then I think the 2023 Biden third step. When you make the transaction, if you decide to do what I just showed you, look at these slides and be careful. And you can't necessarily safely give spouse 1 and spouse 2 100% voting interest in the entity. It's safer to have another party have what's called the liquidation distribution right. But then we went to the Biden third step, which is the two-step is you make a gift and you sell and you get a note back. The third step is, what do you do with it? I want to also mention, and I'm sorry I'm a little bit disjointed here, I think, that for 2025 planning, there's a big elephant in the room, and that elephant is the estate tax going away. And there's 200 congressmen who have gone on record as saying they want to have the estate tax go away. One of them is a Democrat, so the estate tax could go away. Now, if the estate tax, if I'm doing planning this month, perhaps I have a client who's about to have a liquidity event in a year or so, and we really don't want to wait. The client says, well, if the estate tax goes away, I don't want to make a big gift. If the estate tax doesn't go away, I do want to make a big gift. Oh, and by the way, if the estate tax goes away, it could come back in 4 years. It's like a roadshow. So the answer here is to make an installment sale. Put your $700,000 down, sell your $7 million worth of stock to the trust. If the stock explodes and goes up to 20 million, then the trust still owes you a $7 million note. If the estate tax goes away, you can get your 7 million back, and the 14 million is in a trust for the health, education, maintenance, and support of your spouse, which isn't such a bad gig. If the trust is in Nevada or Alaska, Delaware, or South Dakota, the trust protectors could have the power to add you back to the trust. So we are still doing estate tax planning. We are still taking advantage of valuation discounts. And at the same time, we're using these installment sales because it helps to make the transaction reversible. So there's good arguments to keep the note in place, and I've got them here, including number 5, grandfather those low rates. Now you may say, you showed me an example where I could get a $10 million note eliminated in exchange for a $6.5 million payment. Should I do that? And one of the answers is, how long will you live? Definitely do it before you die, so that on your Form 706, we can show $6.5 million in cash or in a building, as opposed to a $10 million face value note that may only be worth $6.5 million. That's going to attract an audit, unless the value of that note keeps you under the estate tax exemption. Reason number 6 to keep the note in place is planning fatigue. The client is tired of us. They don't want to change anything. They don't want another letter. They don't want another meeting. So how you address this could be interesting, but you do now have the ability to say, hey, golly, I called you at home because there's a new tax court case that gives us an indication of something that you should possibly do. Now I'm going to pause here that used to be they would pause for station identification. Does anyone remember that? They would say, hi, this is channel 9 ABC. That's what you're watching. That was the FTC rule back in the 1960s. Completely irrelevant to this presentation, by the way. Okay, so Mary Ann, can they trade out a closely held LLC from the IDGIT in exchange for another asset? Suggestion, if there is the main asset of the trust. Yes, they could take $6.5 million worth of stock in the company back and leave the other $40 million of stock or the other $36 million of stock in the company in. So, Dale, this case went to trial because the IRS was buried. You'll see more. That's interesting. I'm not sure exactly what you mean, Dale. Let me know. David, what happens to the basis step up if there is no estate tax? Might they change that too? Think about 2010. Well, when you have an irrevocable trust, I'll turn off the screen here. When you have an irrevocable trust that you set up that is considered as owned by you for income tax purposes, because you have retained the power to replace trust assets with assets of equal value, for example, and you die, do the assets of that trust get a new income tax basis? Probably 9 out of 10 of my colleagues, and it seems like the really esteemed ones, say that there is definitely no basis step up. But that was really an open question until 2023, when Janet Yellen, then the Treasury Secretary, got a letter in 2022 from a congressman saying it's not fair that this would be out of the estate for estate tax purposes, but there would be a step up. Well, there was an IRS private letter ruling. Some people say it was wrong. It had to do with a foreign situation where the IRS said there was a step up. There was There have been articles by a law professor, Mitch Gans, Jonathan Blottmacher, and others saying that there should be a step up. I believe there should be a step up. Well, when the IRS was, let's say, less taxpayer friendly than it's going to be now, they did issue private letter ruling 2023-2 and said there's no step up. Golly gee, do you think that might be reversed? We will see. We will see. Now, we had a client whose spouse died, and he was told there was no step up, so he filed an income tax return for that trust when it sold the property and paid a $5 million plus income tax bill. And now we have filed a request for refund. Now, when you pay the bill and you file the request for refund, it is very hard for them to penalize you for an overpayment. So I suspect that our client was not the only client who has filed a claim for refund, and if and when the IRS denies it, you may see us in tax court, because I am not at all convinced that you don't get a step up. But if you're concerned that you don't get a step up, if the trust protectors could install a power of appointment in somebody who has a relatively short life expectancy, exercisable in favor of creditors of the estate of that person, then you might get the step up even before the death of the grantor. Okay. David says, hopes and beliefs are not good arguments in tax court. That's very, very wise. What they used to tell us in law school is that if the facts are on your side, pound on the facts. If the law is on your side, pound on the law. And if neither is on your side, pound on the table. So it's important to use courtrooms that have tables. All right. Back to our I wish it was thrilling presentation. What is a promissory note worth? Jerry Hesh wrote a wonderful article on this with a co-author. I forget the co-author's name. And we charted the article. And this gives you the cases that are there. You can read the cases. You can read Jerry's article. If you send me an email, I'll be glad to send you Jerry's article. But there are big discounts to these notes, and you don't have to wait until you die to take the discount. You can take the discount on an estate tax return, but you don't have to. So here's some third step strategies, and we have about 32 minutes left. That's 7/10 of a billable hour for many of you. Number one, get your money or assets back. Number two, don't just sit there with a note. Do something. So, do you want your client to lose the note if they get sued? How about if you put the note in an asset protection trust? How about if, in order to protect the note, you put it into an LLC? Do I have that here somewhere? Let's see. Did I think of that? Yes. I will put the note into an LLC. The LLC will be owned 95% by me, 5% by my daughter. And to make it even better, I'll say that there's 10 voting shares. It's owned 5 voting shares by me, 5 voting shares by my daughter, and 90 non-voting shares by me. Why would I do that? Number one, if I die, there'll be a discount. And number two, if somebody sues me and charging order law applies, they're not going to be able to reach into the LLC to get the note. Or if they sue me and there's no charging order protection, because my daughter has half of the voting rights, they won't be able to take over the LLC, and I can still be the manager. But let's say that I'm not sure if my daughter would disagree with me What if we had a falling out? I could set up an irrevocable trust for my daughter and her descendants and let her be the trustee. Let the trustee hold half the voting stock. I could have the right to replace the trustee with an alternate fiduciary who's not related to me. That gives me dictatorial control at the same time as I'm getting creditor protection. And if I die, that $6.5 million note in the LLC may be valued at less than $5 million when you take into account an LLC discount. So and there's a business reason to do it, and that is the creditor protection. So then page 71, and this is one where I would propose that every client has the right and a reason to know that they can convert their note to an annuity contract, and that may be a better economic arrangement for the client, and it may be a better tax arrangement as well. And speaking of pink hippos, whenever I think of private annuities now, I think of the resin case, because maybe the judge was smoking resin, I don't know, but the asset protection trustee bought the beneficiary of the offshore trust an annuity contract in the Caymans. And the judge said this was not a fraudulent transfer because the grantor of the trust asked the trustee not to do that, but the trustee did it anyway. Now, how many people here believe that the grantor of the trust asked the trustee not to do exactly what was in the best interest of the grantor? And I've got a really nice video by Dennis Kleinfeld, the late great Dennis Kleinfeld, about this case, if anyone would like to watch it. But let's say that your client, I'm on page 72 here, and I got the print really big. See, this is like the old Steve Martin dime trick. So the client has a $10 million promissory note owed to him. Let's say it's at 4 or 5% interest. So he's getting $400,000 or $500,000 a year, and it's going to run out or it's not going to run out. It's going to keep going for, let's say, 10 or 20 years. And this client happens to be 66 years old. He's in good health. The estate tax may go away. Has this been a good deal for him? So he asks his tax advisor, what would I be able to trade this for? What would I be able to get a year in annual payments in exchange for $10 million? And the answer is somewhere here. Maybe where do we have the answer here? Level payment, 3%. The answer is you would divide $10 million by 12.7. So that's what, about 800,000, you could, if you take no payments the first 3 years, then you're going to get what, 640,000 a year? Well, let me come back to this. It's in the letter. Can't remember how the chart worked. It was pretty complicated, wasn't it? Okay, if you have the annuity payment increasing by 3% a year to get 500,000 a year, that's what the client wanted. The first in year 4, and then increasing by 3% a year. The two of you, because it's a joint and survivor annuity for two 66-year-olds, would have to give $8.5 million. So instead of getting 500,000 a year of interest on a 10 million note, they would reduce their note to $1.5 million, and in exchange for the $8.5 million, they would get the same $500,000 a year. That assumes no discount. And as a result of that, on the death of the survivor of them, first of all, the note doesn't have to balloon in 20 years. And secondly, on the death of the survivor of them, there's no estate tax. So that was where the $8,494,000 came in. Let me see if I can figure this thing out. I apologize because I understood it very recently. So then we go back and we say if you could take a discount, then the numbers would be better for your descendants and you could take less. So the end result was a very good one. And I could, if we had time, I don't think we'll have time, but I could take you to estate view and I wouldn't look so stupid. Remember the Kite case. Mrs. Kite put $10.6 million of assets into the trust in exchange for annuity payments that wouldn't even start until 10 years from the date of the transfer. Then it was going to give her $1.9 million a year until death. She required 24-hour nursing care at home at the time she entered into this. She was not in good health. But under the annuity rules, as long as there is no one thing that is more than 50% likely to cause your death within a year of entering into this, it is not considered to be a gift. So for example, I have lung disease. There's a 40% chance it'll kill me within a year. I have heart disease. There's a 42% chance it'll kill me within a year. I have cancer. There's a 37% chance it'll kill me within a year. My chance of dying within a year is 78%, but not one particular cause has more than a 50% chance of putting me under, and therefore I can enter into one of these annuities and have one of these too complicated to ever understand spreadsheets and avoid federal estate tax. Voila. That's another great reason to have the installment sale arrangement, or at least to have a well-funded defective grantor trust in place because of the probability of exhaustion test. And we put in here the exhaustion test value that you would have to have these many millions of dollars in the trust in order to be able to enter into this transaction according to the Treasury regulations. So if you're doing this for 8 or 9 million, the trust needs to typically have 8 or 9 million of other assets in it. That's called the probability of exhaustion test. Now, what if the trust only has 3 million and the exhaustion test says I need 7.8 million? What do? Well, I go to my friend David and I say, David, you have a $10 million net worth. Would you like to make $300,000? And he says, sure, Alan. When I'm done watching this webinar, let's talk about it. So after the webinar, we talk about it. And I say, David, if you'll guarantee this private annuity for this very sick person who's probably going to die in the next couple of years, but if you'll guarantee that this annuity will pay until she is age 110, or at least you'll guarantee it to the extent of $6,500,000, we'll give you $300,000 today. And David says, sure, Alan, no problem. Done deal, after he inspects the medical records. Well, then does that satisfy the probability of exhaustion test? Maybe it does, maybe it doesn't. Has he made a gift to the trust? Well, hopefully he hasn't. It's an arm's length transaction. Well, what if David is a beneficiary of the trust? And what if he's considered by the IRS to have made a gift to the trust? What does that do? Well, then it may not be a grantor trust as to the person who set it up completely. It may be a non-grantor trust to some extent. So David says, where do I sign? I like that. That's very good. The other alternative would be for this couple in their mid-60s to convert the note to a self-canceling installment note. And the interest rate upon conversion, based upon the low rate they have now, if they went with a 15-year skin, it would be 6.1%. If they went with a 23-year skin, it would be 7%. And if they went with a 34-year skin, where it would only have to pay the principal at the end, if one of them makes it to just about 100, it would be 7.8%. Now, some authorities believe that a skin self-canceling installment note, which expires on the death of a person or the surviving spouse of a married couple, has to be set to balloon on the life expectancy of the married couple. According to Professor Hesh, that is not the case. So that's why when we designed our Estate View software, you can go ahead and go beyond the life expectancy to get a higher interest rate. So, you know, maybe the client says, look, I've been at 4%. I think the estate tax is going away. I want a higher rate. All right, well, we can make the note self-canceling to some extent to get you the higher payment you want. And then if you die, it will not be quite so sad as of an event, especially if you die before the note balloons. So that's not to convert the balloon note to the balloon angioplasty, if they still have those. All right, so we talked about converting the note into the annuity. I made a fool of myself because I can't read my own chart. And what about leaving the note to the zeroed out clat? This is another one that we love to illustrate using the estate view. And what is a charitable lead annuity trust? The answer is it's a way to convert what would be subject to estate tax into zero estate tax, a stream of payments to your favorite charity or your family charity, with a remainder interest to your favorite people or your descendants, depending upon who you name to be the beneficiaries. And how does it work? Well, it works fairly well. Especially if you use a discounted asset. So on the client's death, instead of saying I leave it to my daughter Matilda, the client says I leave it to the charitable lead annuity trust to pay payments every year to Matilda's favorite charities, and then on the death, and then 20 years later, or however many years you choose, the rest to Matilda. And zero estate tax, plenty to charity. That's the charitable lead annuity trust, and I have information about them. But an example, a realistic example, would be that you would leave 73% to descendants, 27% to charity. If you get really good results, if you're not very aggressive, you might have 28% to family, 72% to charity. You can't guarantee results. There were people that were putting high interest rate promissory notes into LLCs, into CLATs, where you were guaranteed results. The IRS was ruling on those under the self-dealing rules. They stopped ruling on them. So we've not used them, but that might be an idea. Another idea, and we've done this before, is you put the note in that LLC, of course, for creditor protection purposes, and then 2 or 3 years later, you transfer the 99% non-voting member interest in that LLC to another defective grantor trust, or you sell it maybe even to the original defective grantor trust. Now, that may be pretty aggressive, but if it's legitimate, it has business purpose, and especially if it puts the family under the estate tax filing level, then that can be very useful. So again, we're looking for things that we can do with the note. And if you're going to sell the note, you want to use evaluation formula clause. We prefer the King case, the King clause, to the Wandry clause. In the King case, Mr. or Mrs. King, I don't remember who it was, transferred stock in a company in exchange for a dollar amount, but said if it is determined that the value of the stock is really more or less than what we've agreed to by a court of competent jurisdiction, then either I'll get more for it or I'll give back some. And that's the King clause. And what I like about the King clause is it gets all the stock out of Mr. King's name. The Wandry clause, and you can sell a stock for a Wandry clause, says, I hereby think I'm giving 99 shares or 99% of the stock of this company in exchange for this note or in exchange for this payment, because I think 99% of the company is worth 99 million. But if it turns out that the company is really only worth 88 million and not 99 million, then I've only given 88%, not 99%. So that's a formula clause. The problem with that is that then you've only given 88% and 11% of all the dividends and 11% of the company are still in his estate. It's not as good as a result. In fact, when you run the numbers, you may find that you would have been better without the Wandry clause and just pay the darn gift tax at the time of the transaction if they catch up with you, because the gift tax reduces the estate. So, and again, you want to get the company out of there. So we don't prefer Wandry clauses. We do prefer the King clauses. The other reason is the IRS doesn't like Wandry clauses now with a passion. They are all over these Wandry clauses, and you don't have to wandry why. Ha ha ha. It's not been approved by an actual tax court decision, although it's gotten sort of the nod in another case called Nelson. You don't have an appellate decision supporting Wandry. With King, you've got the 10th Circuit Court of Appeals. So think about the King clause when you're doing these transactions. And then you can also have an overflow port. So you could say in the trust agreement itself, if anyone ever makes a gift to this trust that would be subject to gift tax, the excess goes to my spouse or my favorite family. So that's what that Fawcett is there. And that lady's name is Farrah Fawcett. Okay. Enough of the formulas. Now, the other part of the gift that I just want to mention, because that's what the slide says, is the Q-tip trust rescue. And this is for people who don't want to pay gift tax. No one wants to pay gift tax that I've ever met. But let's say, and I'll have to change this slide someday, let's say that it's 2025 and my client wants to gift a large interest but doesn't want to pay gift tax. Well, what you can do to cut to the chase is, instead of me making a gift to my children, I make a gift to an irrevocable trust that pays Marcia all of its income, and on her death, it goes to our children. And I can make an election on a tax form to cause that trust to be considered a gift from me that will not be considered as owned by Marcia for federal income tax purposes. So I put an $11 million asset, I think it's worth 11, I'm pretty sure it's worth 11 million, into this trust. I make the election. And when do I make the election? I make the election in September of 2026. I make the gift now, but I don't have to decide until September of 2026, if I extend my returns, whether I'm going to consider this to be a marital deduction gift that can then come right out to Marcia and there's no gift made, or a real gift where the Q-tip trust pays her income and stays out of her estate. Now, it's a little leaky because it has to pay her income, but if the asset doesn't pay much in dividends, if maybe the trust purchases stock that pays no dividends, then it's not that leaky. Here's the cool thing. Let's say that I only have 11 million of exemption left because I made a $2,990,000 gift last year to somebody. And let's say I'm afraid that the IRS is going to say that this stock is not worth 11 million. They're going to say that it's worth 1/3 more than that. It's worth 16,500,000, and that I would have made a $5.5 million gift. Well, the regulations to the rescue, I make what's called a formula election. I hereby elect that my gift, my Q-tip trust election is based upon an $11 million gift. If it turns out that it's worth more than 11, then I've made two trusts. One is the non-marital deduction Q-tip for the 11 million. The 5.5 million goes into the marital deduction Q-tip, which will be subject to estate tax when Marcia dies. But I've only made an $11 million gift, and the IRS auditor gets no tax when he audits this, or she audits this. I don't think I did a good job of describing the formula clause, but otherwise, this is how it works. So if you want to make a large gift in 2025, but you don't know if the estate tax is going away, you can use the partial marital deduction Q-tip using a formula election. You have to file that gift tax return. You cannot forget to do that. But that is the lifetime Q-tip. Okay, now, another question. Well, let me see what your questions are, because we have 8 minutes left, known as 3/10 of the billable hour to many of you attending. Okay. Mary Ann, can you give a price range for what to charge a client for doing an IDGIT with an installment note to take into account the work involved and the risk? No, I'd rather not give a price range. I would say that it would be much less than what it would cost to pay the estate tax if you don't do the transaction, and that even if you've done a couple of hundred of these, you have to spend time with the client. You should spend time with any advisors that the client may have, and the more advisors, the better. Make sure you understand the assets. Make sure that you tailor the trust to the family's needs. So it will be thousands of dollars, but it should not be tens of thousands of dollars. Okay, Mary Ann also says, if the LLC is now wholly owned by the client, who is really the brains behind the business, how much control do they need to give up? They don't have to give up control over the entity or over the business. They have to give up any hope of receiving a distribution from the entity, and they have to give up the right to decide if and when the entity will make a distribution. That is because of the Strange case and the Powell case. But they can still keep dictatorial control over that entity. And they should. They're the ones that made it grow. Okay. David says, are there better formula clauses than Wandry? Yes, as I said. Okay. David says, another David says, trust administration is also very important. Yeah, you've got to administer this properly. You have to dot the I's and cross the T's. When I first saw the Ghali case this morning, I was thinking that maybe the taxpayer didn't make interest payments or something like that, or his mother didn't count it in income, but that's not the case. Now, here I say, maybe just do a qualified personal residence trust instead of reducing the note, the client says, hey, I've got $6 million of estate tax exemption. I'm owed a $6 million note. Should I go ahead and reduce the note? You're inclined to say, yes, you should. Well, you might say, hey, you've got a $9 million house. Would you like to get that house and all the growth of the house out of your estate for estate tax purposes? So we ran the number on this, and we found that in some situations, you would be better off doing a qualified personal residence trust and getting the house out of the estate as opposed to getting the note out of the estate. Page 126, give the note some skin, convert the note into a self-canceling installment note. We ran the numbers in 2021. Look at this, 2021. Those were the good old days, right? A long-term note, 1.89%. A skin, 6.5%. Today you're looking at 4.75% or about 4.5% for a non-skin. So the skin was a good idea. I have something we invented, which no one likes but us, but it's called the scrat. And the problem with the skin compared to the private annuity is that the IRS says if you're not in reasonable health, you've got to really charge a much higher interest rate, maybe even above the usury rate, or you'd have to have the note in an Indian tribal jurisdiction where they have no interest rate ceilings, by the way. So people, as you know, on the internet are now borrowing money at 100% interest or higher, 1,000% interest. But anyway, with the self-canceling installment note, you may be making a large gift. That was the subject of the Davidson case. The gentleman was not in good health, and he sold a lot of the Detroit Pistons in exchange for self-canceling installment notes. So what you can do instead is put assets into an LLC in exchange for the skin. The skin, if it's worth, in this example, $1.5 million, and the LLC it has $2 million of assets and owes you $1.5 million, you put that in the Grantor retained annuity trust in exchange for 5 payments of $100,000 or $110,000 a year. You shouldn't have made a big gift if the skin is worth $1.5 million. But if it turns out the skin is only worth $200,000 and that you've really put $1.8 million asset into the GRAT, then you haven't paid a gift tax, you haven't made a gift. It's just that the GRAT now owes you 3 payments of about $300,000 a year each. So the IRS would be discouraged from trying to set your skin transaction aside while you're alive. So we call that the scrat. We thank Stacy Eastland for having a really, really long outline that caused me to fall asleep, and I woke up with the scrat. Somewhere in that outline, I think I derived it from his idea. So the difference between a self-canceling installment note and a private annuity, we've got some nice factors here for you. Love to come back and spend a whole day or at least a whole hour. We could bring Jerry Hash and talk about skins and private annuities and the differences. But the IRS uses that exhaustion test and says you got to have a ton of value in that trust unless you get a guarantee, which may or may not work. Larry Katzenstein thinks that the probability of exhaustion test probably doesn't apply. But in any event, that's where the skin may be a much better situation. But the IRS says, and may be right, that you have to be in reasonable health to do the skin. So in conclusion, I finished accidentally exactly on time. There is a sample letter I can also send you on the Biden third step. And I always welcome your questions, comments, and suggestions on this. Let me see here. Tomer says there was an American Greed episode with a guy that used a Native American tribal organization to evade usury laws and eventually got caught, prosecuted for fraud. Well, charging 100% interest apparently is not fraud if you tell them that you're doing that. So also, I'll mention quickly, the Corporate Transparency Act is basically dead now, except if there is a foreign entity that has registered to do business or has registered to have the ability to do business in any of the 50 states or an Indian tribal jurisdiction, and there are foreign owners or a foreigner in control, then you do have to register under the Corporate Transparency Act. But if it registers in Puerto Rico, Guam, or American Samoa, I don't think they do have to register. So as always, and I said it again, I said it before, so I'll say it again. Thank you so much. Very much appreciate the opportunity to present for you. Love Saturdays at 11. Love you people in California who woke up at 8 for this. The replay will be to you soon. Please forward it to 3 friends and 6 enemies, and have a great rest of your day. We'll see you in 14 minutes to tell you what's new with Estate View if you signed up for that one. Bye.